The parties have to agree to opt out. If there's one party saying no, it goes back to the front of the court. So I'm granting that motion immediately. So if you prepare that UCSO back to front of the court services and an order that says the court ordered opt-in, that's fine. Mr. Farrick, you read the motion, correct?
Correct.
How much back pay is there?
Not what's on this.
Okay, that was what I was wondering. Because otherwise, you get a hearing on how much the back pay is, Mr. Masad, so that you have the chance to prove to the court, your side's easy. Here's how much is owed, here's when it started, and here's the math, add up. Sir, it'd be your job. You got to prove to the court that you paid anything. So I need receipts, checks, bank statements, something to show that you transferred money to her.
Okay. Ironically, we didn't receive a response. I don't know if the court received a written response.
No.
Which could have probably made this process a little bit easier if he would have submitted those.
Right. And what I'm going to do
now we're here.
Well, that's what I'm going to bring up is the fact that because every once in a while I do these when people opt out and then try and opt back in, and I have to go back and recreate the past. It's not easy, which is why I generally warn people when I grant the opt-out, please keep all receipts. And when the child turns 21, have a burn party. But keep them well past the age of 18 and out of high school, just in case there's any arguments. So, but that'll be your burden, sir, is to show what payments you have made. Like I said, months times how much child support owed, easy. That's a multiplication problem. Receipts on payments, that we have to redact. Ma'am, if you have any proof of any payments that you've received, great. According to your motion, you've received none. So I'm giving you that credibility. But that will be the hearing to determine how much is owed. Mr. Farrick, you've got to turn over any receipts that you have at least 1 week prior to the trial. Okay.
Okay.
I'm assuming we're only going to have 2 witnesses, Mr. Masad, the parties. I don't know if we need to exchange witness lists. That would be
Okay, Carmen has anybody else that would need to be there. I mean, she's the one that received the funds. I mean, our exhibit 3 in this case is pretty clear. He could have submitted something back with just a checkpoint saying, here's the check indicating I paid here. Here's the check indicating I paid here, but he didn't. So now we're sitting here. Yeah. So I would ask that you at least at a minimum reserve attorney fees for having to bring this motion.
I will reserve attorney fees. And the hearing is more than likely going to be with referee Kulis Dominguez. As you know, the dockets are being switched. I will be working with the new judge, Judge DeLang. Referee Kulis Dominguez will be working with Judge Bryant. And so this remains a Judge Bryant case. But as of January 3rd, and I know we're not going to get a hearing in next week. So if I could get you in by next week, it'd be mine. But as of the following week, it's going to be with referee Kulis Dominguez. And hopefully you guys will settle it. Sir, look at that spreadsheet. See what corroboration
I just needed time to reserve counsel, which I haven't had enough time to find proper counsel. So that's fine.
Why find counsel, but
no response
in the interim. Well, you have
my income is way different. So this is
it doesn't matter what the income is. It matters what was currently ordered. If you wish to change the support because your income has changed, then you have to file the appropriate motion.
And we will.
Okay, but what is owed is owed. I cannot retroactively change anything.
Understand.
All right, so go back, find what receipt you have while you're looking for counsel, put all that together and match it to the spreadsheet, and maybe exchange that with Mr. Masad before or after you get counsel, either one. Just make sure that it gets done, okay? So the court will be contacting you. I don't know whether referee Kulis Dominguez is doing in-person hearings or is by Zoom, so I normally would ask you. So far, I hear crickets every time I offer an in-person hearing. Everybody's like, oh, no, my living room is much more comfortable than the chairs in the courthouse. So, but that's up to the hearing officer. So, all righty.
I'm just curious, Mr. Farrick, can you tell us what you think you owe?
I haven't looked at it, but I would say 2 months.
Okay.
Maybe now 3 months.
Yeah,
a bunch of those, the reason there are different amounts on there is because there's other things that I paid for an agreement to their sports and other things that made a lesser amount. So for instance, an $1,800 a month instead of the $2,500 something, it's because I covered other things that were discussed the kids.
You better, hopefully you have that in writing. You don't discuss things with the kids and give money to the kids. The money goes to her and through her. So you may have given up something that you may not be able to defend legally. All right. Good luck.
Thank you. Hey, Merry Christmas, Happy
Merry Christmas.
Holidays, whatever you're celebrating.
And whatever you're
Have a great
find
one.
something. I wanted to celebrate Saturnalia this year. That way, the old Roman holiday that they hid Christmas under, because it's like 7 to 10 days celebration. Like that way I can party,
Did
I'm
you
wearing
get your
I'm wearing my Santa Claus tie.
Did you get your Disney on Ice tickets already, I bet?
No. We're doing the Princess Run in February.
All right, there you go.
All righty. Take care,
Have
everybody.
a great
Good
one,
luck.
man. Bye-bye.
You too. Take care. Good to see all of you. Okay. Next. It's my understanding that this is up at the appeals court right now for the current order entered, correct?
Correct.
Okay. And Mr. Bancroft, are you the attorney for the appeal on that as well?
No, we're the respondent. But yeah, I am the attorney on the.
Yeah, you're going to be the attorney on the appeal. And
Correct.
Ms. Brinkman, you are the attorney on the appeal, correct?
Correct.
Okay. I just wanted to set the ground rules because, yes, we have the right to change something in temporary. The question that I have is I've been reading the order and I read it wrong, I think, the very first time. I thought it preserved child support back to February 22nd, but that is not what it did. It says that they're going to use the same numbers. This order leaves blank when the child support is to begin, correct?
Correct. And it was my understanding at the time of mediation and the full spirit of everything there that it would start upon the new order. There was previously an order in effect for quite so many years, 2 or 3
Right.
years, I believe, that did calculate support at 182.5 overnights. And this case, obviously snaked through the court in kind of a non-conventional sort of manner, of course.
Yeah. Well, and the worst part is this is volume 2 and I don't have all the underlying, so I had some other questions because I'm trying to figure out, because retroactive child support I cannot do. But the problem is this may not be retroactive. When was the initial motion filed to get the order that finally was finalized on September 26th?
Well, originally this started out with Helen's attorney, or client, excuse me, was improper filing just a change of, I think just a change of custody. It started out with a name change as well. We then filed after that a motion regarding support, parenting time, and custody, with the guys really focusing on getting a parenting time in effect.
Right, because
the
initial order said 50%. That's all it said about parenting time. It did not designate what that parenting time was. But because the order of September 26th is blank and it refers back to the motion, when did he start 50-50 parenting time? Helen?
Your
Ms.
Honor,
Brinkman? Yes.
my client filed. Yes, can you hear me? I hope you can.
Yeah.
Yes, my client filed according to the FOC report back in January of 2024. It says the parties appear for a joint interview on January, at least by January 8th of 2024. It doesn't say the day of the motion.
Okay, when did the recommendation come out?
Wow.
The recommendation, and I can, if the court needs me to submit the
No, I don't.
calculations and recommendations as an exhibit.
If I want, I can have
the date the date it reads at the bottom. Yeah, the date at the bottom is the calculation completed date was 2/22/2024.
So that is where the 2/22/24 comes in. What is the date that the front of the court used on this child support order? When is the beginning date on that one?
There is no child support order that was entered. It was all
really there was no child support order as part of the recommendation. Then why does the judge? Why is the judge indicating that the FOC is to use the numbers they created then?
That was part of the recommendation, which we objected to, but it never got entered with the.
I'm understanding that. Okay, Ms. LeVay, can you pull up that recommendation and email it to me? I want to take a look at it. This just went, like I said, I had a bunch of questions, but I didn't know which ones to ask.
Yeah. For the record, the defendant did not object to the child support amount. He objected to some other things, but specifically did not object to the child support calculation.
Understood. An objection
50-50
is,
custody.
yeah, well, no, he's had 50-50 custody according to the file since the beginning. It just, there was no designation of what that meant. So I'm stuck with the order of September 26th. It's on appeal. I'm not changing the order. What I'm trying to do is find out if I have a retroactive effect of child support or not, because she did send this to the front of the court to recalculate. So let me see.
I don't know if she sent it to, did she send it to recalculate or calculate? I'm not sure she was aware. I'm not sure she was aware that there had already been a calculation.
And I am looking at the wrong order. You guys have put in so many copies of this blasted order. I keep losing which one is the real one. Okay, I'm looking at a copy of one, but it's a copy of a copy, but it looks like it's all got all the signatures on it. The issue of child support is referred to the Kent County front of the court for a review and recommendation. For the purpose of the review, front of the court shall use the income and other data inputs utilized on February 22nd, 2024 review and recommendation, with the exception of the number of overnights. So it's a very weird wording of this, because she's referring back to something that was done by the front of the court, only to have them recalculate based upon the overnights in this current order. Yeah, they did a child support calculation. And their effective date was 3/1 of 2024. So I believe that since she said using all, well, this order says using all the income and other data inputs. As far as I'm concerned, the effective date is a data input. So whatever calculation will be made as of March 1st, 2024, when they do give their recommendation. So that is not a retroactive effect. That has been preserved. And it is still kind of, it's a football still in the air. It hasn't been caught yet. And there is case law that does indicate that as long as the one case was pretty bad because it was the ball was in the air for 10 years. And they had to go back and recalculate because the front of the court never entered the order and it stayed open for all that length of time. So in this case, I'm thinking that whatever order the front of the court recommends will be changed and altered back to March 1st of 2024. And I'm utilizing the order. How long does what?
I'm sorry. How long does this mom have to on $180 a month until that comes through?
Well, unfortunately,
it's been a year pretty much.
Well, good question. They normally only take about 60 days to get one done, but we have hit the holidays. So if you want, I can try and contact the front of the court and find out where it's at. Let you know. With your permission, I'll call
I think we can do that. We don't have to bother you, Your Honor.
Okay. Oh, well, sometimes they'll answer me quicker than they'll answer you.
That'd be great.
But yeah, it should be coming out very shortly. Yeah, it should be coming out very shortly because it generally only takes them 60 days.
I'm a little confused on what's going on here.
Sure. So what is going on is the order that was entered on September 26th referred the front of the court to do a recommendation based upon child support. Okay. Right. The question is, what effective date should that be? Well, this has all been going on since the beginning of the year. The order effectively states that the only thing to be changed on their recommendation there to use all the same numbers and things, except for the amount of parenting time, which I believe is now 182.5 officially by that order.
The way I understand
in doing that, that means that all effective inputs, one of those inputs was the effective date of March 1st. This has been going on that long. It is not retroactive while, again, everything is still in play. This has been in play since January.
Right. So when they finally do the recalculation of the calculation, they're saying the order that was put in on March 1st is the calculation they're going to use, but they're not going to say that I have to start paying going back to then, right? Because nobody's ever told me any different than.
Well, I'm reading the order. You have it just as well as I do. I'm just interpreting it for you because there was some concern about when it would start. So we'll see.
The order says that the effective date is when the motion or when the order is actually.
No, it doesn't. No, it does not. The order says that all effective inputs other than parenting time will remain in place.
Drew, I'll explain it to you off record.
Yeah, that's the way I'm interpreting it. Now, the good news for you is whatever it comes out to be, and you probably know this because I'm sure you and your attorney have calculated it, it goes into an arrearage. And that arrearage is paid off as a percentage, not as a full amount. It's not due and owing the day it's done. It's entered as an arrearage and will slowly be collected. The bad news for you is anything over 2 months of an arrearage amount is reported to the credit unions under federal law. So the sooner you get it paid off, the better for you. Okay?
So I get a bad credit report rating because of
possible. It's possible when this comes out. It depends on how long it takes you and how much the arrearage is going to be. I don't know what it's going to calculate. It could be calculated at $210 a month.
I don't understand how I can have arrears when I've never been.
All right, you'll need to talk to this. You'll need to talk to your attorney.
I'll explain it to you. I'll explain it to you, Andrew.
All right. Have a good morning, everybody.
Thank you.
All right. Thank you, Your Honor.
And the reason for this is that you don't get to put the ball in the air and keep punting it and then say when it lands, that's where the goal line is. Not happening. Have a good morning.
Okay.
I guess I don't want to run into him at the grocery store, right? And Rebecca, are we doing a pro count at 10 for Bob Rutgers?
Uh-oh. That was very confusing. I'm going to take us off the record. So
Audra's response and then her motion and then your response. Please proceed, sir.
Thank you, Your Honor. Your Honor, we filed a motion to enforce the order that the parties all signed. I did receive a response from Ms. McClure, Ms. Van Loo's attorney, Your Honor, and to be frank with the court, I was not the one that submitted this order with the added Our Family Wizard term to it. This was submitted by Ms. Van Loo's counsel. The order that I submitted was the one that Ms. McClure said contained errors and was not going to be submitted. Again, Your Honor, the parties need to get the benefit of the bargain here. I think if Ms. Van Loo believes that there's issues with intimidation and with the parties not getting along, it would be smart for the parties to have Our Family Wizard. I think that it protects, both the plaintiff and the defendant, and it would allow for Ms. Van Loo to have any evidence of, evidencing a motion for changing custody, which is what she's requesting today, Your Honor. So I think given the facts and circumstances, I think OFW is appropriate for these parties. I think that these parties have agreed to it. I think Ms. Van Loo is now trying to go back on that. Obviously, she read, what was contained in the order that she signed, Your Honor. She just does not want to go along with it because I think it, in so many of these contentious domestic relations cases, it gives one party a win over the other. It doesn't. It's a win for both parties. And I think given the fact that this case is as contentious as it is, I think it's appropriate and the parties need to get the benefit of the bargain, Your Honor. So that's what I would say. And I can answer and respond to Ms. McClure's motion to change custody at the appropriate time.
No problem. Ms. McClure, let's hear your response and your motion.
Thank you, Your Honor. Yes, I think that the motion that we filed to correct the order is obviously related to the motion filed by the plaintiff. I've attached exhibits to try to explain the situation. My client never agreed to use Our Family Wizard. It wasn't ordered by the court in the orally at the motion hearing. And she specifically asked her former counsel to remove that provision. He stated he was removing that provision. Obviously, I have no idea what happened between Mr. Skazgari and her former counsel and those discussions, but
nor the discussions that they had with the judge. Because I believe they met with didn't you meet with the judge, Mr. Skazgari, to get this completed?
We did not, Your Honor.
Oh, okay.
Yeah.
Okay, I apologize. I thought Judge Bryant had input on this. Okay. I'm glad to know that. Thank you, Ms. McClure. Continue.
Yeah, and obviously I'm coming at this later, and I wasn't involved in this. But it wasn't ordered, at least not on the record, and I don't. I think it was probably discussed between counsel at that time, but my client was clear with her former counsel that she wanted that removed and did not authorize the submission of the order that ended up being submitted. So, I mean, obviously I'll leave it to the court to decide whether to order Our Family Wizard at this time or not. My personal experience and what I've discussed with my client is that our family wizard is often used as a weapon by people who want to use it that way. And so I would not recommend it in this case. And it wasn't ordered before. And so to hold my client to, a violation of an order when she didn't, what's never supposed to be part of the order would be extremely unfair at this point. And I guess in response to the claim that she has changed the dentist unilaterally.
I was going to, Mr. Scozzari didn't argue that. It sounded like that one was okay. I'm assuming, Mr. Scozzari, you understood that there was a problem with the former dentist.
I did understand that, Your Honor. I think, Mr. Bergman, just trying to get along here. I think
my question would be, he knew that there was a problem with the former dentist. I don't know what the injury was that occurred, but it sounds like an injury at a dental office, and the dentist then refuses to see the kid, may require a new dentist pretty quickly, correct?
I wouldn't disagree with that.
Okay, then somebody had to make a decision, and that was more of an emergency thing than it was a change of legal at that time. If this is a decent dentist and one that will see the kid, I don't see a problem, but I didn't hear him argue that, Ms. McClure. So I'm assuming that after they talked about it, because when I read your response, because my first thought, Mr. Scozzari, was your client was being a little bit hiding a ball there. If he knew about the problem with the first dentist, he just kind of comes out in your motion with, she changed dentist unilaterally, like there was nothing that occurred that triggered it. The response indicates that there was a trigger and that he knew and that this had to be dealt with. So, at this point, if he wants to argue about who the dentist is, will grant a Lombardo joint legal custody hearing. But again, I don't know exactly what the injury was that happened at the first dentist's office. So, but I'm going to assume that argument is now moot until further argument. Ms. McClure, if you care to proceed.
Thank you. I mean, that was all I had to say about that motion in that order, Your Honor.
Right. Okay. What else let's go on your motion for.
Yes. So I think this motion that we responded to for today was sort of just one in a long line of frivolous motions being filed by the plaintiff. Anytime anything happens, he wants to blame her, but he doesn't want to take a fair share of his responsibility. He's been physically threatening. He will say one thing and change his mind and try to make it seem like she's the problem, or that she said something different than she actually said. He's moved back and forth between locations several times. And I stated in my motion the distances between the parties' homes and the school, but we previously had a Lombardo hearing about school after another, one of the conversations that they had where he said one thing one time and changed his mind later. He lied about where he lived. She's never quite sure where he's living. And there's
it's my understanding he lives at a fiance's house and his parents' house, between the two.
Right.
And I think some of that is to make it feasible to do the custody arrangement that was agreed to. Correct?
I don't think that has anything to do with it.
I'm reading between the lines. I'm assuming distances have something to do with it in the school, since that has been ordered previously. I was assuming that he was going between houses to make it more comfortable for the child to not have to drive as far as. But that's an assumption because I'm reading between the lines.
Sorry.
That's okay.
At one point, I think that might have been true, but during this school year, at least, he's been living at the fiance's house which is, I believe, in the Northview School District, while the child goes to school in Tri-County. So it's not closer. Living at his parents' home would be closer, and there are times when he has done that, but I don't think that decision-making really has anything to do with convenience for the child. It's not. He was at one point doing a week on, week off living situation so he could live closer to the school during his parenting, but that's not what he's been doing for the past year or so. There have been significant troubles between the parties getting an agreement on counseling, as noted in a previous motion. Mr. Bergman at one point refused to schedule any more appointments for the child, even though I believe it was discussed and there was a court order regarding counseling for the child.
Is that court order still in effect?
I believe so.
Okay, in that case, that just needs to be complied with. Is the child in counseling right now?
My client is taking the child to counseling.
Your client is taking the child to counseling? Okay.
Yes, Your Honor.
Okay, so that's being complied with. All right. Continue.
He has obviously the issue with the dentist that was brought up. He brought it up in a motion to try to get my client in trouble, even though that was just I don't want to say it's a normal thing that happens, but it's something that happened that needed to be dealt with. My client was trying to communicate about it, and he decided to just say, "Oh, she changed the dentist. Look at her. She's the bad guy." He's repeatedly failed to attend to the child's medical needs during his parenting time, including sending him, just putting Tylenol on the kid and sending him to school. The kid ended up having pneumonia. Mr. Bergman did not want to take any responsibility for that or admit that.
And what did the school have to say about that?
Well, I don't think the school was informed. They don't have anything to say.
They were the ones that caught the temperature and the pneumonia, right?
No, my client did.
So the school didn't notice the child was sick?
Well,
he attended school all day, and the school didn't notice the child was sick?
School all day, all week long. And
okay.
Mr. Bergman,
and the school did not notice any problems?
I don't know what the school might have talked to Mr. Bergman about. He was given Tylenol in the morning. And so he didn't have a fever when he arrived at school.
Okay.
I'm sure he was dragging by the end of the day. But if he had gotten medical attention to begin with, he probably wouldn't have developed pneumonia, according to what the doctor told my client when she was able to get the child to the doctor.
Okay, and when was that?
That was when the child came back to her house and she noticed that he was very sick.
Okay.
And he told her, oh yeah, I've just been given Tylenol.
Okay, and it was alleviating the symptoms, correct?
Well, it didn't.
I'm sorry,
I mean, the recommendation would have been, and again, this is during Mr. Bergman's parenting time. We don't know all the details of what happened, but if he had been given rest and maybe taken a day or two off of school, he likely wouldn't have developed pneumonia. Maybe he would have. We don't know for sure. But he didn't tell my client that the child was sick, said nothing about it. And it turns out he's been sick for the whole week during his parenting time.
All right, we're done here. Let me be blunt. Your client's complaining that he's the one doing all this, yet she's doing the same kind of complaining against him. These two need to both grow up. Both of them are acting like children. Both of them need to deal with the current order. And with what you just argued, I'm ordering my family wizard, so I'm going to order compliance with this. If she's complaining that he's always changing his mind and stuff, that's what my family wizard is for. So no, don't make the complaint and then say, but I'm going to take away and I don't agree. No, she's just as bad as he is. I'm not saying either party is perfect. I don't expect them to be, but I do expect them to act like grown-ups. And right now, the court is not going to get into little arguments between the two because they don't get along. I'll get into the big arguments. You ain't made one yet. Motion denied on change of custody. Motion to enforce granted. Have a good morning.
Thank you.
Thank you.
Next.
You can do.
Sorry, I knew that argument would go on for another 10 minutes, so if not 20 if I let them. 0DP. At this point in time, I have a motion before the court by Ms. Andrews for child support. And at this time, is there anything you have to add to your motion, Ms. Andrews? I thought you connected, Ms. Andrews. Is there anything you'd like to add? No, you didn't. I thought I heard her voice. Sorry. Can you hear me? Okay, so we just need to hear you. That normally means you're connected. Maybe your phone doesn't have a mic. That would be weird. Oh, you're using the earbuds.
Can you hear me now?
Yeah, the earbuds were countermanding the mic. Okay.
Okay.
All right. What do you have to add to your motion now?
Nothing. Pretty much I just said all that I had to say. I want my case to be reviewed for some type of support. I'm not getting any support.
Understood. Mr. Longmire, what do you have to add to this? I didn't get a response from you, sir.
This is the first of me knowing anything about any of this, so that's why I was trying to figure out.
Well, basically, she's alleged the requisite change of circumstance to review the child support. So the court normally is going to, the court is going to send this to the front of the court for a review of child support. Okay.
Okay.
The child support can be reviewed at any time with the requisite change of circumstance. That's a change of income, large changes in, losing jobs, gaining jobs. She's got the requisite that we've got a change in how much the parenting time is being utilized compared to what was previously ordered. That's enough to review the child support. Okay.
Okay, that's fine.
You have a good morning. Both of you take care. Merry Christmas.
All right. So how long do I wait for my papers?
Well, it's Christmas and New Year's, so give it about 3 weeks, and then make sure you have your most current pay stub available. At this time of the year, your last pay stub of the year should be very helpful, because that'll say how many.
Because mine is self-employed, so.
Okay, then you're going to have your taxes for the last 3 years available.
Okay, that's fine.
All right, so get the last 3 years of taxes and get those ready for the front of the court. The defendant's former attorney. And she confirmed that since it's 21 days past the entry of the judgment, she is no longer the attorney of record. What I need to confirm with you, because I was wondering why she wasn't here. That's why we're delaying. That's why we waited, because we were expecting her.
Okay. I just sent, a note a minute ago because she said she wouldn't be representing. He said he would be here by himself.
Yeah, well, he's not here. And this matter was set for a hearing at 8:30. It is now 9:36. So we are going to proceed on the motion. Now, I've read your motion. Let's see if we can get you through this.
Because part of it has been resolved because after I filed the motion around Thanksgiving, my oldest son brought me the deeds.
Okay, good.
Sign, so I did. Okay. And then I brought those over and had them recorded because I didn't want to take a chance that he wouldn't record it.
So smart move. Because what I can do is also issue you an order that says that the judgment may be entered as a quitclaim deed.
Okay. And then the title to the car.
Now that I can grant you an order that changes the title that you can take down to
the
Secretary of State. What you need to do is make an order that says that the court orders that the title of the car, VIN number, whatever, type in the VIN number and the make and model and year. Okay.
Okay.
And that should change the title at the Secretary of State because a court order can do it as well.
Okay. Because he did try to sign the title. I gave it to my daughter and said, have him sign here. And he decided he would sign wherever he wanted to.
Wherever he wanted, and that's not going to be good enough. So I'm granting you the court order to change the title.
Okay. Can you?
Now, I have a question. Is the VIN on the judgment?
Or
do they just name the car?
It might be in the judgment. Probably not on the court.
I'm looking. I'm trying to business, bank accounts, vehicles. No, they didn't put the VIN number in the vehicle, just the type of vehicle it is. So just the Legal Assistance Center at the 5th floor of the courthouse can help you draft that order, but you need your VIN number.
I'm a legal assistant, so.
Oh, I was going to say, the motion looked pretty nicely done. So you can draft the order yourself then.
Yes, I kind of do this every day, so.
Yeah, well,
can you order him to pay any, like the motion fee or the recording fee, or he's just he's told me he just wants to make my life miserable, which is why he's cost me so much money.
Before I do that, let me ask this question. What do you want to do about the pontoon? Has it been brought up to speed?
I didn't get a late notification, but I'm frustrated because I gave him all the money and then it's just, I did everything for him the last 35 years. So
is the firm you work with a family law firm?
No, it's not. So I actually had to hire a firm to represent me. And
the rule in family law is no good deed goes unpunished. Always be careful.
Mm-hmm.
Okay. There's no winner here. There's just varying degrees of losing. But as long as I'm trying to figure out what to do for you on the pontoon boat. How much have you spent so far on filing fees and how much is it going to cost for?
Well, I mean, personally, just this motion is all I filed on besides.
And was there a cost to this motion?
$20.
Oh, okay.
Yeah. And then the recording fee I paid because it wasn't worth not having it done.
All right. So you've taken care of both of those. I'm granting you the order on the car. What do you want to do about the pontoon?
What can I do? Can you force him to?
I can grant you the order that the judgment of divorce is to be enforced and he is to continue making payments on time. If he misses another payment, that you may request that the pontoon be sold.
Okay.
Okay.
And that's what I would like then.
Put that in that same order.
Okay.
And then send it to me and I will sign it. You can send it under 7-day rule.
Okay. All right. I will go ahead and do that. I'm just trying we got kids coming home and I'm like, just sign the document. Let's be done. And we just
it's hard. It's always hard to undo an I do.
Yes.
You say those two words.
I know. I didn't want to be divorced. It's just,
Understand.
I've done enough for a long time.
I'm granting you the relief that you have requested because he is not complying with the judgment of divorce. I will not hold him in contempt at this time since there's no request for that. And it basically is just a word at this point. It's a slap on the wrist. What I'm holding him to is the judgment.
Okay.
And I'll put the condition on there that if he misses another pontoon payment, that you may request the pontoon to be sold.
Okay.
All righty.
All right. So I will get that over to the court then.
No problem.
Thank you.
You have a good morning.
You too. Thank you.
77DS. All right, next. I have a question. Wasn't there a guardianship in this case?
Yes.
Yeah.
Is the child still in a guardianship?
No, she's with me now.
She's with you now. Okay. And what is the current ordered parenting time?
There is no ordered parenting time. Well, there was through the guardianship, but there isn't anymore.
Okay, well, that with the guardianship being dissolved, hold on, I'm trying to set the stage here, Mr. Colgrove. With the guardianship being dissolved, the orders of the court in this case go back into play. So this was sent to the front of the court, and then there was a recommendation that was sent out on February 15th, 2024. It does not look like that was ever entered. What does anybody know what happened to that?
What recommendation is that?
Every other weekend, every other holiday.
It's not part of the court order.
Okay.
Well,
so the only court order in here says that parenting time is by agreement of the parties. If there's no agreement, then there's no parenting.
I didn't know that. I thought there was.
Well, that's why I'm trying to set the stage, because I'm trying to find out where you both are at, because there's been a guardianship intervention, and nobody told me about what was going on with the guardianship. Normally, the probate court under the guardianship controls parenting time. This court then has no authority. Once the guardianship is dissolved, the orders in this case go back into play. And I was just trying to figure out, because it says a recommendation was sent out.
I didn't know there other thing. I thought there was an order through the child support, but I wasn't sure what it was.
The order of the child support indicates, because this was brought by the prosecutor, not by either one of you. This was because of state aid in the case. Okay. All right. So they only dealt with child support. But the order, trying to find the right order now, orders that the mother has initial custody of the child without prejudice to the determination of either parent's custodial rights in the future. Respondent has the right to parenting time as previously ordered. If no order or prior provision exists, then parenting time shall be by the agreement of the parties.
Okay.
Yeah.
That is where this stands.
I just didn't know. That sounds fine.
Can I say something, sir?
Sure. I was gonna give you the chance. I was trying to set the stage, tell you where you're all at.
Yeah.
Okay.
All right. May I proceed?
Yes.
All right. Well, there's really no agreement on the party, because she hasn't been letting me see my like the last hearing where she got guardianship. They haven't let me see my child for a couple weeks, and I still haven't been seeing my kid. So they told me to go file an order to proceed the last order, because there was an order set before the guardianship, and I was getting her every other it said every other weekend, and it said every other holiday.
Yeah, and again, I don't see that order in the court file.
Yeah, and me and her don't have an agreement, because she's not
right. And if there's no agreement, then there's no parenting time at this point. She has control.
Right. So I have to
she has sole custody.
Right.
So but she has some concerns here about what's happening when you do have parenting time, and that's why she stopped it.
Well, allegations.
What? Yeah, those are allegations, but
absurd. Yeah.
In what way are they absurd?
Well, because there was no problem until me and her had some type of argument. Then after that, now she says my daughter's acting up. She comes to my house. She does this. Because my daughter says things when she comes to my house that her mom treats her bad, cusses her. I never bring that type of stuff up. I just remind my daughter that she's loved. So.
Okay. All righty.
Yeah.
Well, at this point, her order was to terminate any parenting time, but there's no parenting time to terminate because I don't have any orders for parenting time.
Yeah.
So what I would need you to do is file the appropriate motion.
I am.
And ma'am, Ms. Pickens, I have a question, because that way I don't have to waste both of your time. And because of this holidays, the court has no choice but to send it to the front of the court for a parenting time review, which is where you have the right to ask for the parenting classes and stuff, and he has the right to ask for parenting time. That's going to happen. There's only going to be a delay on this, by 4 weeks, and there's already a delay due to the holidays because they're not going to get to you till February. Okay, would it be okay if I send this to the front of the court now and circumvent you guys having to come back, or do you want? Because you have the right to have him file the appropriate motion to ask for why he wants parenting time, and then you can respond to it. But again,
you can go ahead and send it if that makes more sense to do.
Yeah, I will send it to the front of the court for custody and parenting time. I'm sorry, parenting time and child support, because those are both reviewable. That circumvents your need for a motion, but you guys have the right to file supplemental.
Yeah. Is all of that necessary? Do we need to do that though? Do I need to do that?
Send it to to go through the front of the court for parenting time? It's eventually going to get there because the law has no choice. Each of you are both parents to this child. Parenting time shall be granted if it's safe.
Yeah, and it is.
So your argument is it's not safe. His argument is it is. But the front of the court's going to eventually review this.
Okay, that's cool.
Okay. Yeah. And again, you have the right, because they'll contact you and they'll want to know what your concerns are. How old is this child?
5.
She's 5.
Okay. And you have the right to bring your concerns to the court. He has the right to prove that those are not concerns. And then they have the ability to make a recommendation on how to proceed with doing parenting time safely.
Yes.
Because again, it's going to be granted by law as long as it can be done safely.
Yes.
And the question would then be how to proceed. Okay.
Hey, sir. So
yeah.
Do I go to? So I talked to the last judge, and because I never had any problems with my dog. Like, I've been seeing her for the past year. I started with supervised, unsupervised. Now I have her overnight, and it's just these little minor, minuscule allegations.
That's why I'm sending it to the front of the court for them to vet out. I can't vet all that out on a Friday morning.
I understand that, sir. And do I go file, because I'm in the process of filing a motion for an order for family court. That's what the last judge told me. So
that's where you're at right now.
So do I have to find any more paperwork to get in front of a?
I'm trying. If you paid any attention to what I just did, I'm trying to circumvent that and send it straight to the front of the court now.
Yes, sir.
Instead of you filing a motion and both of you having to take off work and come back in 4 weeks for a motion that I'm going to have to grant to the front of the court anyway.
Right. Oh, you're right. Sorry about that. I'm sorry.
Okay. Any questions?
No, I'm fine.
Okay. The fees were waived by the judge in this matter, so the $300 fee for the front of the court review will be waived. Okay. I wish both of you luck. Have a Merry Christmas and Happy Holidays.
Thank you, sir.
Thank you.
Bye-bye.
God bless.
Next, 302 DC. I've read your motion, Ms. Warden. I did not get a response from you, sir. Have you read the motion?
No.
Okay. It appears that according to her, it's your intention to say that you don't want to have parenting time or be involved with the child. Is that correct?
Yes, at the time.
Okay, so you want me to suspend your parenting time?
Change. Yes.
Okay. I have a question, Ms. Warden. Would you, because it's an odd request. I've had it maybe a handful of times in my career. So some people sometimes do this. My question to you, Ms. Warden, would be, do you want me to suspend it as he's requested, or do you want me to leave it parenting time as agreed? That way, if the child ever wants to see him, you have the right to let the child.
Okay, so during the time of this, during the motion I had filed, it was what I had written, and then I went back to the courthouse to expedite it. And then I wanted to change it to him having him on the weekends. because I'm a single mom in school full time.
Okay. So you would prefer it to be parenting time as agreed?
Yes.
Okay. Mr. Mazariagos, that would allow you to see the child when and if available. Okay.
Yep.
The court would prefer that because both of you are still parents to this child.
Yes.
I don't know what's going on in your life, sir, that you would want to suspend your parenting time. Like I said, it's not a request. I've seen it done before because sometimes people are going through things in their own life and they realize that they can't handle the stress or whatever. Parenting is a lot of work, but it is also something the child deserves. But at this point in time, I will make the parenting time to be as agreed by the parties, and I will draft that order myself. Okay? Anything else?
What if we can't come to an agreement about the parenting time?
The agreement is by you. You're in control. You have custody. So if there's no agreement, there's no parenting time.
What does that mean exactly?
It means that if he's asked for this weekend and you say, I've got plans, you can say there's no agreement. You're not going to get up the child this weekend.
But even if there's an old court-ordered one?
That's why I'm entering the order that says parenting time by agreement. Okay. That's what you requested for it to be suspended. He requested it to be suspended. I'm just inquiring if that's really what the two of you want.
No.
Okay. So you would prefer it to be by agreement then?
Yes.
Okay. In that case, that is how I will set this out. Parenting time will be by agreement of the parties. Is there anything else I can do for both of you?
So do I have to make another court appointment so
for
it can
what?
be to have like a schedule?
Okay, now I'm really confused. So you want this set for specific parenting time?
Yes.
Okay, because your request was to say that he wants to be absolved and you wanted full custody and you wanted to stop parenting time. That was your motion.
I went back to the courthouse to try to change it and they wouldn't let me.
Okay. Okay. That's what you were trying to tell me. Yes. I was trying to figure out what was going on. Okay. I apologize. No.
That's okay.
Okay. So I'm okay because I'm confused by the motion before me. Mr. Mazariagos, what is your input on having any time with this child? I mean, you are the father.
Yeah, I wanted time with him. It's just that at the time that this was all happening, I was going through a mental issue.
Like I said, sometimes there are people that are going through some things. And we do suspend for a short period of time, but once that's over, we can also move on. I mean, parenting time and child support are reviewable anytime up to the child is 18 and out of high school.
Yeah.
Okay. So how old is this child?
4 years old.
4? Okay. So we got another 14 years yet. And Ms. Warden, you would like a specific parenting time?
I would because I'm in school and okay, so let me restart. I asked Jose last night if there was any days that he wanted and didn't want so I could work around because I'm not trying to make anybody upset. I'm not asking for any more child support. Like I'm trying to be very workable around with. I myself go to school 5 days a week.
Right.
And I take Kai to school every day that he's in school. He's in school 4 days a week because it does not align with Jose's schedule. So I asked for Jose to have Kai Friday, Saturday, Sunday.
Okay.
Because I
Which
go
is
to
what he's got alternating weekends from Saturday to Monday.
Yeah.
Was that done because of a work schedule?
This was so long ago.
Okay. All righty. I have a question. Do the two of you think you can sit down with a mediator and actually put something together, or do you need a full front of the court recommendation?
Like a mediator in front of the court?
A mediator, yeah, in front of the court has mediation available that they can sit down with you and help you draft an order together. Because let's face it, I don't know your schedules. I don't know your school schedule. That's not in the motion. I don't know what his work schedule is. I don't know what your work schedule is. I don't know what the child's schedule is. So for me to order some parenting time right now might do more harm than good.
Can I please have the mediator then?
Well, I'm asking if you guys think you can sit down together and come up with an idea, because the mediator can only enter what the two of you agree to. The front of the court review would allow them to make a recommendation regardless of what the two of you agree to. So I'm just asking because I don't know how you two get along. It sounds like you get along semi-okay.
We don't get along.
No.
Okay. Well, the fees have been waived in this case, so I will send this to the front of the court for a full review. Make sure you have your schedules done, ready and prepared, so that we know when your schedules are. That way we know when you're available, and the child's schedule. That way we know when the child's available, so that the front of the court can help make a recommendation to get you through this.
Okay, thank you.
Merry Christmas. Good luck with the child. Good. Take care. Okay.
Yes.
All righty. Okay, I was confused.
Yeah, for real.
Let me get this straight. That did start with her requesting it to be suspended and him agreeing that he wanted it suspended. Okay. Just wanted to know if I was going a little cuckoo. Again, this is the 5th Monday of the week. Okay, what county is the CPS case, the Protective Services case in?
Kent.
Kent, it is here. Okay, good. When is the next neglect hearing?
You're talking about like the foster care court hearing?
I'm talking about the court hearing, yes.
I have it written down. I apologize. Give me a second.
Relax. I should note for the record that this matter was set for a hearing at, double check the time here, at 9:30. It is now 10 o'clock, and I will note the defendant is not present, but there may be a reason for that. Yes.
January 14th is the actual court date where we decide what happens next. And then on the 30th, actually, we have the family team meeting, which we sort of talk about things and what's going to happen in court, sort of, I guess.
Okay, yeah, that's pretty much the procedure. A third of what I do is abuse, neglect, a third is juvenile delinquency, and a third is the divorces. So what I would needed to know from you is CPS indicating they would close their case if I change custody?
Do you mean foster care?
Well, you said you have custody of the child right now, correct?
Yep, through foster care still.
Wait, is the child physically with you or not?
Yes, every night.
Okay. Yeah. Why is it through foster care if you're the father?
I was in a treatment program last year. I started actually at the beginning of 2023, and I completed it. Actually, it took me about 13 months to get through the program and get everything set up.
But the child is physically with you right now.
Yeah, he has been for 5 or so months now. Yeah.
Okay. Yep. But it's through the neglect system that they've placed. What kind of parenting time does the mother have?
She sporadically shows up to her visits, which I think is right now it's like 2 hours twice a week, but her attendance is at like 25%.
All right, understood. I guess my question is, have they indicated to you that they would close the neglect case if I change custody to you?
I have had a lot of indications about that, yeah.
Okay. The reason that I'm asking that is because we need to kind of bring all of this together. Okay. What time on the 14th of January?
She actually, I had someone working with me. I didn't get the actual time, I guess. I have it written down for sure.
Okay. Miss
I apologize for that.
Hold on. Miss LeVay, can you look up the neglect case in this matter under Brian's name?
Yes.
And see what we've got going.
As far as the CPS reports kind of thing, or
what I'm trying to do is coincide this. I need to hear from CPS that they truly want to close their case if I change custody. That makes a hearing a lot easier and quicker, because what they typically want to do is give one parent custody if the other parent is not doing well. Instead of terminating on the other parent's rights, they'll change custody in the custody matter, and then they'll drop the neglect case as long as certain orders are put in place to protect the child in the divorce case or the custody case.
I can't see orders, like certain orders for the neglect case. I do see there's a permanency planning review hearing with Judge Bryant on January 14.
At what time?
3 p.m.
Okay. Then I am going to do a hearing at 4 p.m. Okay. And I know that might overlap with my delinquency hearings, Ms. LeVay, but we'll get to them as soon after 4 p.m. as possible. That way we know what's going on with the permanency planning hearing. And I need to talk to the judge about that so that we can coincide these things, because I'm going to keep this case because it'll be a quick hearing. All right.
I have
you have a 3 o'clock hearing on the 14th with judge. I'm assuming that's by Zoom, or is it in person?
Did you want referee to come in? Are you asking me?
Yes. Ms. LeVay?
Oh, one moment, please.
Oh, no problem. What we normally do is I set it up so that we do this close right after the hearing on the neglect matter, because if CPS indicates that they want the custody switched, we will typically go through the factors. I'll put you under oath and we'll go through everything necessary, and we'll make the appropriate orders at an appropriate hearing. But that way we have protective services indicating fully what their intentions are. Okay? It's just a process right now. We just have to do it in the right order. Okay?
Okay.
Sounds like you're doing everything fine and doing everything well. Congratulations.
Thank you. I appreciate that. Thank you so much.
Thank you for stepping up. And,
yeah, absolutely. Yeah.
You know, we do these every once in a while, but that is the order of things. Go to the team meeting, tell them that I said I'm going to set a hearing right after their permanency planning hearing. And that way, if, you know, I'll do the hearing, and if that switches custody, they can issue an order afterwards that is known as a JC 36 that closes their case.
Okay.
All right. And we'll discuss parenting time for the mother at that time. It may need to be supervised at a professional agency if it happens at all. Okay.
Okay. All right. It was good to meet you. Thank you.
It's nice to meet you too. So I will see you on the 14th at 4 o'clock. Sounds like you have an afternoon ahead of you.
Company party today, actually. So.
Oh well, I mean, the afternoon of the 14th. It's going to be. It's going to be a little bit busy.
No, just like today, like a lot of stuff going on, and so. But thank you.
No problem. You take care. I'll see you on the 14th.
Okay, bye.
All right.
And that's via Zoom.
That's via Zoom. It'll be the same Zoom meeting number.
Okay. I'll go to court to get that number then, or.
Okay. The Zoom number for me at 4 o'clock, it's the same one you just used.
Okay. I'm writing it down right now. Thank you so much.
And I'm sorry, were you talking about judge's hearing, Rebecca?
Correct. That's via Zoom.
Okay. And the judge's hearing is by Zoom too at her Zoom meeting number. Okay. And I'll try and remember to zoom in maybe at that meeting and find out what's going on.
Okay.
All right.
I'm writing this one down. Okay. Thank you.
No problem.
Okay.
Have a good day, sir. Have an enjoyable party. Merry Christmas.
Right. Bonus check. Okay. Bye.
Oh, bonus check. That's even better. Yeah.
All right.
Mr. Hilderly, good to see you again. How you doing?
Good to see you. I'm doing well. How are you?
Wonderful. After that last fiasco we had, which was no fault of yours. In any event, let's go ahead and go on the record. Oh, wait, let me make sure. Miss Lopez, did you connect?
Yes, I'm here.
Okay, good. Are you at least parked safely?
Yes, I am.
Okay. Especially with the weather. It took me 3 hours to get home last night. So I'm worried about people right now because my house is right next to 96 and I'm watching the traffic not doing well. So in any event, we are here in the matter of Lopez versus Lopez. Mr. Lopez is not present. And I know that you properly noticed him, correct, Mr. Hilderly?
Yes, Your Honor.
Okay. I'm going to grant your motion to give her exclusive use of the home. My question is, we do have 2 kids here. It's kind of odd not to bring up custody, parenting time, and child support. Any thoughts? I mean, Mr. Lopez is still living at the house, correct?
Yes.
Okay. And I will give him the 30 days to vacate. So he should be vacated by the time we get the order in, he should be vacated by February 1st.
Okay.
So the month of January. As to, you guys have been married for what, 3.5 years, 4 years?
October was 3 years.
Okay. How long ago did you buy the house?
I bought the house in 2018.
Okay. Were you together when you bought the house?
Mostly.
Okay. Was he living at the house then?
He moved in with me when I moved in.
Okay. Because there is still a marital portion of the house. So whatever it increased in value during the 3 years, it may be your separate property because it's in your name and you bought it before you were married. But there's still possible, that there's an argument, but if he doesn't show up to make the argument, we'll do what's fair. Okay.
Right. Okay.
But I'm going to grant your motion, Mr. Hilderly, as it's set forth. But any thoughts on custody, parenting time, and child support? Do you just want to put that off until mediation?
I was hopeful that by the time we had this happen that we there would be that mediation. I haven't seen it come back yet. I'm not sure.
What triggers it is he has to file a response.
Yeah, that's what I
then
figured.
It sets the scheduling conference. That's why I was asking if there's something you wanted me to do to get the ball rolling on this. You know, because it doesn't seem like
I'm trying to see. I think he was served on the 4th.
Let's see. This was filed on November 7th. And in accordance, date and time of service was December 2nd.
December 2nd.
Yeah.
Okay. So maybe if we pursue the default, would that move anything?
Then you just proceed on for entry of the judgment of divorce through default.
I think that's maybe the way.
Okay. That's why I was just asking, because all I'm trying to do is I don't want to make an argument for him, but at the same time, I want to make an argument and try and do what's best for the kids.
I understand.
But in any event, though, I will let you proceed then I just was wondering if you know the case better than I do. So all I'm trying to do is help you get through it.
Okay.
All right.
Thank you. We'll submit
Ms. Lopez, good luck, and submit that order, and we'll have to move out by February. Now, you will be maintaining all costs and everything with the house.
I've done so.
You've done so since the beginning? Yeah, okay. All righty. But yeah, if you're living there, you pay the bills. All righty. That's kind of the gist of the motion, was that you've been paying it all along, but I was just trying to figure out what how long and what thing's been going on. All right. Have a good morning. Take care of yourselves.
All right. Thank you.
All right.
Bye.
Bye.